Which judge is right after them? Okay. Okay, good afternoon. It's an honour and a privilege for me to provide the introductory remarks to this esteemed panel of judges. And in fact, actually, it's a privilege for me to present before such an esteemed audience. I have to say, it's really a who's who of animal law out there. I can see many of my heroes and inspirations in the audience. But the judges are Maria Alejandra Mauricio, Judge Arthur Minella, and Judge Carla Andrade Quevedo. And the rulings rendered by these judges are an inspiration for the global animal protection movement, and I think lay the foundations for an animal rights jurisprudence of the future. And I suspect many others in this room, felt a great sense of hope and joy when reading them, and they really represent glimmers of light in a largely dark and gloomy legal landscape for non-human animals. And reading these judgments, for me, recalls the Arundhati Roy quote, another world is not only possible, she is on her way. On a quiet day, I can hear her breathing. And pro-animal rights judgments, I should say, are exceedingly rare. Why is this? Well, obviously there's lots of reasons for this, but I suspect one of them is that judges are worried about their reputation. They don't want to be seen as radicals or rocking the boat too much or stepping beyond their judicial boundaries. But I think this panel of judges shows us that those fears are not well-founded. They demonstrate that you can make groundbreaking, yet plausible animal rights rulings and remain respected jurists. Judge Minella, for example, has ascended to Pakistan's highest court after delivering his infamous ruling in 2020, which I was going to call the Kavan ruling, but as he just correctly reminded me, there were lots of other inmates that he freed in that ruling. And in addition, let's think about Judge Rowan Wilson of the New York Court of Appeals. As most of you are aware, I'm sure, in 2021, he delivered a groundbreaking 70-plus page dissent in the Happy the Elephant case, in which he said he would recognise an elephant's right to seek habeas corpus relief before the courts. Has he been shunned as a result? No, in fact, he's been promoted to Chief Judge. He's now the highest-ranking member of judicial office in New York State. And I think the moral of the story here is that judges can afford to show the bravery, the integrity, and the creativity that this panel of judges have demonstrated. Animal rights are no longer a fringe belief. More and more people are waking up to the realities of the horrendous ways that humans continue to mistreat the other animals and the various existential threats that these forms of treatment have for humans themselves. And it seems like the status quo really can't continue, and courts have an important role to play in applying existing legal doctrines and legal principles to make sense of the social realities of the Anthropocene. In my introductory remarks, I'm not going to be saying anything more about these rulings. Their authors are here, and it's far more important to hear what they've got to say about them. So instead, I'm going to provide a brief overview of some of the theoretical and practical issues relating to animal rights litigation. And the starting point, of course, is to get clear on what we mean by animal rights litigation. I think we know what litigation means, but what do we mean by animal rights? Of course, in a broad sense, as Raphael was saying this morning, we could just mean all legal protections that animals currently have in the law. But again, as Raphael suggested, that's not really the sort of animal rights this conference is interested in, and it's not the sort of rights the Cambridge Centre for Animal Rights Law was established to study and research. Indeed, I take much of the present study and research and practices around what we call animal rights law to be understood precisely as looking to alternatives to the status quo, to the current way of doing things. And more precisely, I think when we're thinking about animal rights litigation, we're thinking about something that aims to move beyond the traditional animal welfare legal paradigm in three important ways. First, I'd claim that animal rights litigation aims at winning what we can call fundamental rights for animals. And these can be understood as rights that are akin to human rights in terms of their protective scope and strength. Secondly, animal rights litigation seeks to win a new legal status for animals that goes beyond their present classification as objects or things or property. Finally, animal rights litigation seeks to get legal standing recognised for animals so that they, through their legal representatives, have the ability to enforce their rights directly in court. Now, to be clear, I'm not suggesting that every instance of animal rights litigation will aim at all three of these objectives, but I think these are nonetheless recurring themes of animal rights litigation, and I take animal rights litigation to be involved in pursuing one or more of these objectives. So let's have a look at them in turn, starting first with fundamental rights. And this will be somewhat redolent of Raphael's remarks this morning. And I claim that we can think of fundamental rights as having three core features. Firstly, they're rights that protect the basic or fundamental interests of the rights holder rather than merely trivial interests. And of course, there's different ways of conceptualizing what a fundamental interest is, but we can basically just think of them as really important interests that individuals have. So think, for example, about access to food and shelter or freedom from torture. These seem like fundamental interests that both humans and non-human animals share. Secondly, fundamental rights offer broad protection for those basic interests as opposed to narrow protection. And thirdly, fundamental rights protect those basic interests in a robust rather than a weak manner. Now, Saskia Stuckey, who's in the audience somewhere, I think she has convincingly argued that existing animal welfare laws fall short of one or both of the second and third criteria here. So just to illustrate an animal welfare law that fails the second limb of what a fundamental right is, take something like a prohibition on cosmetics testing, which was mentioned in the previous panel. Now, a ban on cosmetics testing on animals clearly meets the first criterion. It protects a basic or fundamental interest of an animal in avoiding suffering, but it fails the second prong because it only protects this interest in a very narrow way. Because, of course, there's all sorts of other harmful interferences with an animal's body that causes them suffering, like toxicity testing or something, for example. And so an example of what a fundamental right would look like would be something like a right to bodily integrity for animals, that would apply broadly to all harmful interferences with an animal's body. And so I think this broad normative scope is an essential component of a fundamental right. And then there are also examples of animal welfare laws that are going to fail the third criterion of protecting these interests robustly, which I'm sure most people are aware of. So take, for example, that cornerstone of animal protection laws, the prohibition on causing unnecessary suffering for animals. When judges are figuring out whether suffering inflicted on an animal is necessary or unnecessary, they engage in a balancing exercise in which they weigh the human's interest in inflicting the suffering for some instrumental purpose against the animal's interest in not having the suffering inflicted on them, and then usually in a highly anthropocentric manner, weigh those two interests against each other, which means, of course, that all animals' basic interests in avoiding suffering can easily be overridden by countervailing human and other interests. Okay, so to provide an illustration of what litigation for fundamental animal rights looks like, consider the increasingly popular habeas corpus strategy. And this has been litigated on behalf of non-human animals in many jurisdictions now. And in fact, all three of the judgments we're going to hear about had elements of habeas corpus in the argumentation, although it's only in the Cecilia case that it was determinative to the outcome. Now, habeas corpus, I would argue, meets, or the writ of habeas corpus protects fundamental rights because it meets all three criteria. So firstly, it protects a basic interest, I would argue. It protects an interest in freedom from unjust confinement, which I would argue is a basic interest that all sentient beings have. Habeas corpus also protects this broadly, at least in theory, insofar as it applies to all forms of unjust confinement. And in the animal context, of course, that can mean zoos, circuses, research laboratories, or detention in a private home. So it has a broad scope of application. And finally, habeas corpus protects these interests robustly insofar as an unjust form of confinement doesn't become lawful merely because the jailer can show that they or wider society benefit from the detention. Now, of course, this is an idealised picture of habeas corpus I've given you. Its real-world applications are a lot messier, but it does, at least in theory, protect the contours of what we mean by a fundamental right, I'd argue. Okay, just going to turn briefly to the second two features of animal rights litigation. One of these involves changing the legal status of animals from mere objects of the law into subjects of the law. And so animal rights advocates have roundly criticised various existing legal classifications of animals as objects and things and property. And they criticise these classifications for helping to facilitate the instrumental exploitation of animals as resources and also entrenching animals' status as subordinate to the interests of humans. So the second objective of animal rights litigation then is to encourage a shift away from this status and to get the legal subjecthood of animals recognised. And this subjecthood status might be something like legal personhood. We see this term used in the habeas corpus cases and in the Cecilia case we'll be hearing about shortly. Or it might be something like a subject of law, a legal subject, or a subject of rights, which is the language used in the Estragita case we'll also be hearing about shortly. Okay, third feature of animal rights litigation is closely connected with the second objective, and it involves trying to get animals not only substantive fundamental rights, but also procedural rights to ensure that those substantive rights can be enforced in court. Now, current standing rules differ significantly from jurisdiction to jurisdiction, but in most jurisdictions, animals are not presently regarded as parties to legal disputes, although South America is an increasingly progressive exception to this, I'd note. And so having rights enforced by animals themselves through their representatives in court, as problematic as ideas of representation are, as Angela noted this morning, I think plays an important part in shifting away from this view of animals as mere objects of law. Okay, so I've just set out some of the theoretical contours of what I take to be some of the core defining features of animal rights litigation. So I just want to wrap up by reflecting on some of the practical barriers to achieving victories in animal rights litigation and some of the strategies that have been deployed to address them. Okay. This is the problem, fundamentally. We have deeply anthropocentric legal orders. So the objects of animal rights litigation, right, fundamental rights for all sentient beings, granting them full legal subjecthood and legal standing, is really incompatible with the ways that our current societies are structured. Right? Our current societies are structured around the mass exploitation and extermination of animals. This is part of the social fabric of our societies at present. And judicial decrees can only go so far. They can only outpace the social and cultural realities of society by so much and remain feasible. Simply put, this is the key challenge for animal rights litigators, and I think the key challenge is to try and find a sweet spot between mere pragmatism and idealism. This involves finding a way to move things forward in an animal rights respecting direction, whilst also not pushing things so far that there's no plausible chance a court will be prepared to go there. And there are at least two broad strategies that animal rights advocates have tried so far. And the first of these is to try and narrow the class of animals whose fundamental rights they seek to vindicate in the courts. And there are different ways we can think of this subclass of animals, or different lines that could be pursued. So we could look at animals who are very human-like the non-human great apes, for example. We could look at endangered wild species. We could look at species that are considered sacred, or we could look at companion animals. Those are just a few possible examples. And which of those will be the most successful will, of course, depend on the cultural and legal traditions of the jurisdiction in question. The second strategy is to try and expand rights for animals more broadly, but somewhat water down the content of those rights so that maybe they are stronger than existing animal welfare laws, but weaker than human rights, for example. Right? They might be susceptible to more exemptions and restrictions, for example. So in this sort of strategic domain, there's this trade-off between breadth and depth. Right? There's deep and narrow, or wider and shallower avenues that can go down. And the strengths and weaknesses of both are in fact the strengths and weaknesses of the other. But I'll leave it there, and I'm going to now hand the floor to Judge Maria Alejandra Mauricio.